Smart home security devices help to prevent crime, but how do your legal rights balance against the rights of your neighbours to protect their homes and film you? John Woodard's neighbour was unhappy with his use of CCTV and a Ring Doorbell. She took him to court, and John now faces a hefty bill for compensation. I'm Daniel Barnett, a barrister based in central London, and I'm also the presenter of the LBC Legal Hour. In this video, I'll explain when home security could overstep data protection laws, what actions could constitute harassment, and your legal right to enjoy your home. Owners of CCTV and smart devices such as Ring doorbells gather and process personal data. That's information that can be used to identify somebody. They do this by recording video and/or audio footage and then storing it. Anyone processing personal data is subject to the GDPR guidelines and to the Data Protection Act. Those make it clear that people can only gather personal data in a way that's lawful, fair, and transparent. Now, there are three things they need to show in order to stay on the right side of the law. First, they have to have a legal justification for recording footage. Now, in the case of home security, your neighbour is trying to protect their property. That falls under legitimate interests. It's something we're all allowed to do as long as we don't break other laws along the way. Next, they have to show that processing personal data is necessary for this purpose. Now, Ring doorbells and CCTV will usually, I emphasize usually, pass this test because the data captured can help to catch the perpetrators of crime as well as preventing the crime in the first place. However, if your neighbour could achieve the same results with less impact on your privacy, then they may be deemed to have gone beyond the realms of necessity. For example, they might be able to use a camera that's more directly focused on their own property, or turn off the audio settings so that they're just capturing video. Finally, they've got to show their interests aren't overridden by the interests or fundamental rights and freedoms of the data subject. In other words, their right to security shouldn't outweigh the consequential impact on your privacy. Now, that's going to depend on individual circumstances, such as where your neighbour's cameras are facing, how far away they're activated, and at what point they can pick up the audio. What your neighbour chooses to do with the data and how long they keep it is also important. For example, if your neighbour has a Ring doorbell that's motion activated when you approach their house, then the data it picks up is clearly important for crime prevention. That will usually outweigh the fact that it might incidentally record a few seconds of footage of people in the background. But if the entrance to your property is directly in the line of vision of your neighbour's camera and it picks up audio and visual footage whenever you or your visitors go in or out of your house, then the courts might order that particular camera to be removed and you may, just may, be eligible for compensation. In extreme cases, your neighbour's behaviour could constitute harassment. Now, the legal test here is whether a reasonable person in the same circumstances would have been able to reasonably foresee that their actions would cause you distress. Your neighbour has the right to argue that their actions are for the purposes of preventing or detecting crime, but they'd have to be able to back this up, something John Woodard, in the case I mentioned a few minutes ago, was unable to do. Now, in that case, John Woodard had told his neighbour that he'd sent footage of her to the police. This was totally unwarranted because he knew that she posed no threat to him, and he'd only told her this to intimidate her. Most people's neighbours are more considerate than this, of course, but there's a chance you might be able to bring about a claim of private nuisance. This is where the consequences of someone's actions on their land spills over onto your land and affects your enjoyment of your own property. Now, you can only use this law if you own your property. That was established in a case called Hunter and Canary Wharf, and your land has to be damaged either physically or because it's become less useful to you. Remember, your neighbour does have a right to use their property in a reasonable way even if that's not ideal for you. So in order to succeed in your claim, you've got to be able to prove that the interference with your property is substantial, because it happened frequently or over a prolonged period of time, as it did in a case called Kennaway and Thompson. Now in that case, Kennaway and Thompson, two neighbours were embroiled in an argument about the defendant's motor boat racing club activities. The judge held that although the claimant had moved into her property in the full knowledge that boat races would occur and that she'd have to put up with some disturbances, the boats had for some years become bigger and noisier and races more frequent, and so caused her substantial loss of enjoyment of her house. Now she was awarded damages, and on appeal she was awarded an injunction against the defendant, restricting the number of racing days and restricting the total volume of activities allowed on the lake during other times. You might be able to invoke private nuisance laws if, say, your neighbour's CCTV or Ring camera often records your conversations when you're in your garden, as this reduces your ability to enjoy that area of your property. Now, where the arguments for and against your case are roughly equal, the court might take into account your neighbour's intentions. If they deliberately aim to cause you problems, then this would probably tip the balance in your favour. Otherwise, you'll have to live and let live. In cases of nuisance, you might get an injunction against your neighbour, preventing them from using the offending equipment, or you might be awarded compensation. So for neighbours who use devices like CCTV or a Ring Doorbell in a reasonable way, you won't have a legal claim against them. But if their smart security systems disproportionately impact on your privacy, reduce your ability to enjoy your land, or amount to harassment, then there is legal protection for you. In Fairhurst and Woodard, some of John Woodard's security cameras, including his Ring Doorbell, had video and audio settings that reached beyond the boundaries of his property. He boasted to his neighbour, Dr. Fairhurst, that he could access footage from his extensive surveillance at any time. Now, she was concerned that she and her visitors would be recorded whenever they entered her property. John antagonised the situation by repeatedly lying and threatening her. Eventually, this led to Dr. Fairhurst moving out of her home for a period of time, and she brought a case against him for breach of privacy, for harassment, and for causing her nuisance. The nuisance claim was dismissed by the judge because although a light shone into Dr. Fairhurst's conservatory whenever one of the cameras was activated, the judge said this wasn't particularly unreasonable and it didn't greatly reduce her enjoyment or use of the house. She lived in a city where it's accepted that people have to put up with a degree of light pollution. It was also found that some of Mr. Woodard's security devices were legitimate and only incidentally captured footage of the claimant, but others broke data protection laws. One camera because it pointed directly into a communal area, and the Ring Doorbell because it captured the audio of his neighbour at a great distance. John's behaviour towards Dr. Fairhurst was by any reasonable standards intimidating and amounted to harassment. His arguments as to why he behaved in such a way were also dismissed by the judge as victim blaming. Now, please give this video a thumbs up, subscribe, and take a look at my other legal explainers like this one on what to do if you've got noisy neighbours. I'm Barrister Daniel Barnett. Thank you for watching. Bye bye.